Good morning, everyone, and welcome to today's session. We are joined this to meet today. So, without any waste of time, position of the business.
Beloved, for today, the 7th day of February 2023. We have just a case before you, and that is the case of Armed Forces of Nigeria against N5759 Seaman Abbas Haruna.
Okay, bring in the two person. Defense Council, are you ready for the business of today?
It's an insinuation from the defense counsel that the accused is saying that he does not understand the last charge, the last count charge read to him. It will be for the interest of justice for the accused to actually inform the court whether he understands or does not understand. If actually he does not understand, that means that it is the responsibility of the JA to also read it again to him. If it requires explanation, he can as well explain. So we want to hear from the accused person. Accused person, if you don't understand, tell the court that you don't understand. Because you can only take your plea on a charge that you understand. Are you hearing me?
Yes, sir.
So, having read this count 3 to you, tell this court, do you understand the charge, or should I read it again that you don't understand? You understand the charge?
Yes, sir.
Okay. Having informed the court that you understand the charge, how do you plead? Guilty or not guilty on that charge? They are giving you another leverage, another time, another opportunity to make your plea, because this is a proceedings for change of plea. If actually you want to change your plea in this charge, you have told the court you understand the charge. Is it not?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Guilty, sir. Should temper justice. Mercy.
Okay. Thank you, Your Lordships, distinguished members of this Honorable General Court. The charge has once again been read to the accused person. 3 count charges read to the accused person. And in line with the proceedings for change of plea, that's happened. It asks to enable him to change his plea. He has successfully pleaded guilty to the 3 count charges. It's now left for the court to deliberate, and as well to go deliberate on the change of plea of the accused person, and as well, having studied the countenance of the accused person, his demeanor in the process, in the proceedings of change of plea, should be able to determine whether to accept the plea of change of plea that he made or not. It boils down to the court in line with the rules of procedure. I humbly request the court to go for deliberation and as well come back to inform the court whether they will accept the change of plea or not. Prosecution, you have anything to say?
Just for record purpose, and to be seen that justice is not only done, but is manifestly done. And my lords, reading through there's naval commercial procedure for Royal Navy, the provisions is similar to what are obtained in the rules of procedure army. They need to explain to the accused person the implication of his plea of guilty, the likely punishments that are waiting, and the fact that the court will go ahead to enter even the maximum punishment provided in the Armed Forces Act. And the procedure, although I think it's very important that these are explained on record to the accused person before the court retire to deliberate and to come up with a decision whether to accept the pleas or not. That's my humble observation.
Defense, any response to that?
Yes, my learned senior has said it all, to have the record straight. So that is what the rule says. In the rule of the court, I don't think we have to exercise discretion. So let's exhaust it. That's our own observation.
At this point, the accused person has actually pleaded to the 3 counts charge. It is incumbent on the judge advocate, in line with the rules of procedure, Royal Navy DR 11, which is synonymous to that of rules of procedure Army 1972. It states that whenever the accused person pleads to the charge, guilty to the charge, it is the responsibility and incumbent on the judge advocate to explain the implication of his change of plea. The implication of his change of plea, and again the discretion of the court to go ahead and enter judgment in line with his plea of guilty. The accused, now I'm addressing you. You have made a change of plea to the 3 count charges which was read to you. It implies that you have given the court, you have asked the court to go ahead and deliberate on whether to accept the plea on the ground that they have the power to go ahead as well to punish enter any judgment. The implication is that you have submitted yourself for judgment. You are asking the court to enter any judgment, even when the court decides to enter the maximum judgment against you, that it is what you have accepted by faith. And of course, the court has the discretion as well to put into consideration the fact that we have all as well pleaded guilty to those offenses. So the court will go for deliberation, and when they come as well, they will as well consider to accept or not to accept. Where the court accepts their plea, their change of plea, of guilty, they will enter judgment, and whatever they enter as a judgment, you accept it because you have pleaded guilty to the all count charges. When the court refuses to accept, it means that they are going to go for full trial, and it's now the onus will now be shifted to the prosecution to call their witnesses. And the implication is that they are going to go for full trial, and when they go for full trial, they will call their witnesses to testify against you. And when they do not go for full trial, it means the court has the power to enter judgment, and that's you will have to bear the liability of the punishment. Do you understand? The court should go ahead, deliberate, and come back that you are accepting, you have agreed, as you pleaded guilty to the 3 count charges, that you are not in duress, you are not under influence, that it is their wish that you accepted this plea of guilty that you pleaded on the 3 count charges.
Yes, sir.
Thank you. Your Lordship, is now for the court to go to inner chambers for further deliberation and to come out with a conclusion on whether to accept the plea of guilty or not. Please, Your Lordship. Thank you.
All right. At this point, the court will rise to go and deliberate on the accused written change of plea. When we return, we'll give our ruling. All right. Okay, let's have appearance once again.
The notes for the prosecution will remain Major J. Omo, Captain M.P. Zigma, and Captain M.P. Oku.
With all most respect, my Lord, I am still Chukwu and Augustine. My learned friend S.M. Webji will be joining me shortly. Our humble appearance is still by the place. My Lord be pleased.
Okay, this court has been deliberated as to the plea of guilty by the accused rating. This court hereby accepts the plea of guilty. Therefore, request the prosecution to avail the court with the summary and abstract of this.
Thank you, Lord. May I most respectfully apply that you permit me to hand over the mic to my learned friend, Captain Sitman, to continue from here.
in line with the accused's change plea from not guilty to guilty, and following my Lord's ruling accepting the change of plea, my Lord, the prosecution will proceed under the court-martial procedures for Royal Navy, otherwise known as ER11. Those provisions are similar to that of the Rules of Procedure Army 1972, to the effect that the abstract of evidence be read to the court in further proof of the charges against the accused rating. Now, accordingly, my Lord, we shall proceed. My Lord, it is the case of the prosecution that sometime on or about 1600 hours of November 2019, the accused soldier joined the parade for the address of the commanding officer, 20 Battalion, where the commanding officer was to address troops preparatory to an operation that the battalion was to embark on. While the CEO was addressing the troops, the accused soldier continually interrupted the address, which warranted the commanding officer to, in person of Colonel MS Adamu, to order for the restraint of the accused to be taken into custody because of his behavior. But the accused soldier refused to obey the order for his arrest, which informed his being charged on count 1. My Lord, it was also, or it is our case also, that the accused soldier in the same address of the commanding officer, because of his interruption of the proceedings of the address by the commanding officer, opened fire, thereby expending about 16 rounds of 7.62 mm special ammunition in order to prevent soldiers from arresting him and taking him into custody. My Lord, it was also established that Lord, as we said earlier, having expended the 16 rounds, which are properties of the Nigerian Navy, my Lord, that informed our charging the accused in count 2 for offense in relation to public and service property under Section 66 of the Armed Forces Act, A20, Laws of the Federation of Nigeria. My Lord, in summary, my Lord, the accused soldier, during the address by the commanding officer, disobeyed the lawful order given by the commanding officer for his arrest and detention. The accused also resisted arrest when attempt was made by one Lieutenant Abbas and some other soldiers to take him into custody. He refused and opened fire to prevent his arrest. My Lord, in summary, these were the facts that informed the charges against the accused, rating for which he is currently standing trial. My Lord, in further proof of the case against the accused rating, we shall tender the following documents in evidence. Watch my Lord to admit the documents, mark them as exhibits in this case. First, my Lord, is the statement made by the accused himself, the voluntary statement made by the accused person, as well as the interrogatory form made by SM Abbas Haruna. My Lord, the prosecution shall also be tendering in evidence the statement made by Lieutenant Olusegun Remy Samuel, a voluntary statement made by the said officer, Lieutenant R.S. Olusegun, dated 24th November 2019. My Lord, the statement of the accused person is dated 23rd November 2019. Both the voluntary and the interrogatory form by the accused is dated 23rd November 2019. My Lord, the prosecution shall also be tendering in evidence the statement of Flying Officer I.M.D.K. dated 24th November 2019. Lord, we shall also be tendering in evidence a statement made by Lance Corporal Babagona Abubakar, dated 23rd November 2019, as well as the statement of voluntary statement of Lance Corporal Stephen Andrew, as well as the interrogatory form by the said Lance Corporal Stephen Andrew, both dated 24th November 2019. My Lord, I urge my lords to admit these documents in evidence, mark them as exhibits, and further proof of our case against the accused, and proceed accordingly, my Lord, to sentence him accordingly. Lord, that is our humble submission.
Defense, any response to the document sought to be tendered in evidence?
My Lord, documents will duly served on us, and they will not have any objection as to their admissibility. And my Lord, be pleased.
Thank you.
Since the defense counsel did not object to the admissibility of all the documents sought to be tendered the prosecution. This court hereby admits him in advance, and request the judge advocate to go ahead and mark all the documents accordingly as exhibits in this case. Thank you.
Your Lordships, distinguished members, President, at this point, may I humbly request to go ahead and mark the exhibits, the documents as exhibits in this case. Military Statement Form 51A, made by M5759, Seaman Abbas Haruna, dated 23rd November 2019, is hereby admitted in evidence and marked as Exhibit A. Interrogation form made by M5759 Seaman Abbas Haruna, dated 23rd November 2019, is hereby admitted in evidence and marked as Exhibit B. Military Statement Form 51A, made by Lieutenant Olusegun Remisamo, N/15929, dated 24 November 2019, is hereby admitted in evidence and marked as Exhibit C. Military Statement Form 51A, made by Flight Officer D.K. Ikenna Martins, NAF/4055, dated 24 November 2019, is hereby admitted in evidence and marked as Exhibit D. Military Statement Form 51A, made by 13NA/69/2394, Lance Corporal Babakana Abubakar, dated 23rd November 2019, is hereby admitted in evidence and marked as Exhibit E. Military Statement Form 51A, made by 13/27766, NAF 13/27766, Last Corporal Stephen Andrew Otu, dated 24 November 2019, is hereby admitted in evidence and marked as Exhibit F. Interrogation form made by NAF 13/27766, Last Corporal Stephen Andrew Otu, dated 24 November 2019, is hereby admitted in evidence and marked as Exhibit G. At this point, Your Lordship, the documents have all been admitted in evidence and marked accordingly. It is the requisite requirement that the accused person, through his counsel and himself as well, should be given the opportunity to make plea allocutus, in other words, plea in mitigation, before the court go in for their deliberation and final judgment. Defense counsel.
Yes, very well, my Lord. As is routine, this plea mitigation ought to be initiated by the convicted rector himself, except that in a given circumstance. Since in every general rule, there is always an exception. I'm a privileged daughters of the Lordships to say that, rising from the principle that law is dynamic and is always given a human face to meet the need and circumstances of a particular time, I've given the daughters of my Lordships to salvage the timing of this court and to do the allocutus behalf of the convicted directly. The court reserves the discretion to do that. They might not be placed.
Prosecution, have anything to that? If not, the court will consider whether to grant that or not.
Yes, my lord, the learned brothers and the Supreme Court have spoken with regards to the issue of plea mitigation, which by authority it is the convict that ought to make his plea in mitigation. My lord, the prosecution will not have any issues. However, if there is anything to indicate that the convict himself cannot do so, otherwise, by virtue of that authority, it is the convict that ought to make his plea in mitigation, which the counsel can then round up. But we do not have any issues if my lords yes, my lord, that is also our submission, that if my lords confirm that the convict cannot do that by himself, nothing stops counsel from doing so. After all, my lord, plea mitigation does not change what the law provides as to the punishment that is appropriate. It is at the discretion of the court to consider that. And that is our response.
Okay. Your Lordships, the President, distinguished members, the defense counsel just made an application, a very harmless economic application to go ahead and make the plea of mitigation on behalf of the accused person, considering the circumstances surrounding this case. That is his word. And in response to that, the prosecution said that, of course, they don't have any issue with that, but the court should first and foremost confirm if the accused person has one or two things to say. Where it is obvious that he has nothing to say, the prosecution, the defense can go ahead and make the mitigation. At this point, I will want to bring the indulgence of the Lordships to humbly ask the accused person, who is now convict before this court, to know whether he has one or two words that could be appealable to the heart of the court, one or two words that he wants the court to know in pleading for leniency, one or two words that he wants to tell the court for court to consider in reaching their judgments. Do you have anyone accused person? Do you have anything to tell the court? Any appeal, any plead, anything you want to show, anything you want to tell them to do for you?
No, sir. We want the court to impart justice to this.
Is that all we want the court to do for you?
Yes, sir.
To temper justice with mercy. Okay. Thank you. Defense, you can proceed from there. Thank you.
We're very grateful, my Lord, and for my learned friends for being adherents to the law. Yes, having said that, my Lord, the convicted rector has said it all, that this court should temper justice with mercy. It is saying so, my Lord. His countenance said it all before now. His his physique, his demeanor shows a man of asking for mercy. My Lord, as it stands, you have the yam and you have the knife. The convict has shown enough remorse. He even started that the day he even mandated his lawyer to tell this court that, please, I've offended. I don't need to take the time of the court. I don't need to take the resources of the state, whose property are also damaged and whose laws are desecrated. My Lord, we humbly want to enjoin your lordships to the philosophy behind punishment. As far as justice must be seen to have been served. Justice, like we always say, is a tripodial arm. Justice for the state, whose laws are desecrated. Justice for the victim, whose blood is crying for vengeance. Yet, even the almighty offender is also looking up to you for justice. And we urge your lordships to not just do justice, but to do it manifestly, so that even an ordinary man on the street will believe that justice has been done. And how do we do this in this particular case? There is no two cases that are similar, my Lord. And that is why your lordships, in your wisdom, always deal with cases according to its merit. We urge your lordships to check, go down memory lane, and see the circumstances of this case, or the case of the convict and his demeanor. And again, arising from the policy document on sentencing, that when a man who is brought to justice or brought to trial has surrendered and said, here am I, do unto me what I will. My Lord, that you should indeed touch that side of the milk of a mother, that side of the chest of a mother. Little wonder why the symbol of justice is a woman, because we know that women have mercy, they have force for their children. Women are mother to all. That is why we come to you, my Lord, to say, considering the general circumstances of this case, and the convicted soldier rating has come to say, I have offended, please hamper justice with mercy. That you do not brush the bathtub with the baby. Throw away the bad water, but please keep the baby. And Lord, it might interest you to know that seated in this court, seated before your Lordship, is the weeping wife of the convicted rating, with eyes bulging out of weeping and crying, having the faith of not just the convict, but the faith of the family, the generation unborn that are coming from him, crying to you for mercy. So he's a married man with a family. And without taking your time, there are plethora of regime of punishments that can be meted out to the convicted rector. And having asked you to temper justice in this, it includes but not limited to even you go and sin no more. Just as Christ did to a woman, to the harlot, who was brought before the author of justice to be stoned to death. That's the punishment for the woman caught in prostitution in the then days. But when the woman was presented, Christ, the Almighty, the Judge, my Lord, with all due respect, and not sounding blasphemous, this bench today, as far as human affairs is concerned, concerning this conflict, is taking the position of the Almighty to decide the fate of humanity. And we know that we are men of record and conscience who have milk of honey flowing in your chest to know that the convicted soldier, convicted rector, has shown remorse and wished that that day never existed as part of the history of his life. And to consider the fact that as of 2019, I think he was barely 4 years in service. As of today, I think he's of 29 years of age, which means as of 2019, he could be just 21. Can it not be said that in addition to whatever influence that might have engendered that action, that he was still wallowing in the euphoria of youthful exuberance? And these are the facts we considered, and we join him to say, yes, we don't even need to take the time of this court by coming to go into full trial. Trial what? What we know we did? So it is on this note, my God, and considering the overriding policy direction, that when a man has come to plead guilty, that the punishment regime should be reduced drastically. My Lord, we know there are as many as 3 humongous charges on him, yet in the spirit of plea of guilty without going to the full trial, we shall still be urging your lordships to look at the minutest regime of punishment that is available and consider that, and everything we have said about the convicted rector, to give your sentence with a very mild and human face, so that the very purpose of this sitting, which is conviction, is even enough. It's even enough. Yes, we committed, and the court was said, and has been convicted. It is on this note, my Lord, that we can't take too much of the time, that we commit it to the hands of God, and to say that as we retire to deliberate on the sentence regime, that should factor all these mitigating factors, including but not limited to the fact that from every background indication we have, it's also a first-time offender. Yes, agreed that through the benevolence of the jurisdictional authority, let me not say convening authority, that the unit where he is now, we cannot say there has been an invitation Yet, he served detention up until sometime August 2022, until he was remanded for medical treatment. So my Lord, we simply urge your lordships and most humbly request that as you go to deliberate on the regime of punishment, and you factor all these mitigating reasonings to play and to tamper justice with mercy and to sentence with mildness, not allowing the gavel, the sledgehammer, which is dangling on his head. We know the punishments available. I don't think anyone is demanding anything less than 2 years. So if we can go that height, that means we'll be crushed. And like we said, it is not just about him, but the people who are depending on him. May my noble Lord be pleased, and may God guide your wisdom.
Okay. I've been listening to the plea of indication that the convicted rating and the addendum from the defense counsel. This court will go for a break in order to deliberate on the sentence. And when we return, we'll give our judgment. Let's have a prayer song.
Beloved, with profound respect and humility, we remit Major J. O. Captain N.P. Zitman, and Captain N.E. Oku for the prosecution.
And my noble Lord be pleased, Chukwu and Abbas for the defense, and Lord, my learned friend will soon be joining us. No, but we're not ready to go. We're done.
Okay, without wasting of time, go straight to the award of punishment. Award of punishment by this General Court Martial in the case of Armed Forces of Nigeria versus M5159 Seaman Abbas Haruna. The accused rating was charged on 3 charges of disobedience to particular orders, resistance to arrest, an offense in the relation to public and service property, contrary to Section 56 of Section 1, Section 86 of Section 1, and Section 66 of Section C, respectively, of the Armed Forces Act of 820 Law of the Federation of Nigeria 2004. The accused rating was earlier arraigned before the court and he pleaded not guilty to the 3-count charges. However, the Defense Counsel made an application in line with the rules of procedure Royal Navy BR 11, which is in consonance with the rule of procedure Army 1972. To this court, to enable the accused rating change his plea. The application was not opposed by the prosecution counsel on the ground that it is the right of the accused rating to change his plea anytime during the proceeding before judgment. The accused rating pleaded guilty to the 3-count charges, and his plea of guilty were duly accepted by this court. The prosecution thereafter availed this court with the summary and abstract of evidence. The prosecution further tendered 7 documents as exhibits in this case. The defense, however, did not object to all of the documents, and they were admitted in evidence and marked as exhibits A to G. The accused rating himself made a plea of mitigation of punishment. He personally appealed to this court to temper justice with mercy. Thereafter, the defense counsel submitted that the accused rating may have committed the offense as a result of his inexperience in service, looking at the number of years he spent in service, which was nearly 4 years as at the time of the commission of the offense. He further pleaded with the court to consider the adverse effect of the punishment to be awarded to the accused rating by this court. However, in all of the submissions of the defense counsel in his plea of mitigation, this court consistently observed that the countenance of the accused rating is more of unremorseful and unapologetic. The accused rating attitude of disobedience to lawful authority, which was indeed similar to one of the count charges which he faced in this criminal trial, continued to manifest even while the proceeding was ongoing. It is therefore out of the principle of justice and fair trial that this court accepted the accused rating change of plea. However, this court will not be deterred from ensuring that justice is meted out in this case. One can only imagine the action of the accused rating when he disobeyed the order of a senior officer and yet blatantly resisted arrest and still went as far as expending 16 rounds of 7.62mm special. What agitates the mind of this court is that the action of the accused rating could have resulted in the death of any of his colleagues, which could have occurred from his sporadic shooting. The action of the accused rating is no doubt an act of gross indiscipline, capable of taking the lives of his colleagues. It is now evident that the accused rating, by his action, can never be trusted with rifle in the armed forces of Nigeria. And if so, it therefore means that as a rating in the Nigerian Navy, who cannot be entrusted with rifle, there is no doubt that he will not be useful to the Nigerian Navy and indeed the armed forces of Nigeria anymore, since soldiers, rating and aircraft men are trained for the purpose of weapon handling and judicial applications when called upon for the protection of the sovereignty of the Federal Republic of Nigeria. Consequently, this General Court Martial find the accused guilty on the 3-count charges as he earlier pleaded. This court thereby sentenced M5759 seaman Abbas Haruna as follows. Count 1 on disobedience to particular orders, reduction in rank from seaman to ordinary seaman. Count 2 on resistance to arrest, dismissal with enormity from the armed forces. Count 3 on offense in relation to public and service property, dismissal with enormity from the armed forces. However, counts 2 and 3 shall run concurrently. This judgment is, however, subject to confirmation by the appropriate superior authority. This judgment is dated this 7th February 2022.
We shall not bet time of industry and your magnanimity, even though in your sentence. We say we're very grateful, and may the Almighty continue to guide you as you continue your other deliberations. That's our appreciation.
The prosecution, any other thing?
My Lord, we very much appreciate the court for the industry and the well-balanced judgment and sentence. It will go a long way to send a message, strong one, to any other would-be offender. My Lord, on this note, we want to most respectfully announce that that's the end, the only case, at the end of the cases we brought before this General Court Martial for today and for the time being, and maybe subject to the overriding decision of the convening authority, the court may adjourn sine die. Thank you, my Lord.
Okay, having to tell the cases that are presented before this court for the time being. This court is hereby adjourned indefinitely